reception cocktail, and it's downstairs. So if you go out, there's out and to the left, stairs going down. Free drinks. Not sure about the food. Okay. So this panel is to discuss some of the current challenges in relation to cyber operations. And I think we all know that it's been quite a few years, the better part of a decade at least, that it's been very, very clear that cyber operations have become a major talking point in the world of international law. And what's been interesting for those that were following it is that for many of these years, a lot of the discussion around cyber operations was rooted very firmly in international humanitarian law, laws of armed conflict. And there are all sorts of reasons why we've been discussing cyber in the context of armed conflict and IHL. I'll point out just two, but there are others. One is that many states, including some prominent states and those very much involved and operating in this field, placed their cyber defense and attack capabilities in the hands of the military. Military or defense ministries, and that meant that those of us looking at it automatically started thinking about cyber operations being discussed as a form of a military operation. Another reason that we've been talking about cyber and humanitarian law all the time is because the humanitarian lawyers are extremely active, engaged, and bright. I'm talking about the other ones, but they are people who are sort of on top of what's going on. And a lot of the people in the field of international humanitarian law quickly realized that, and there were maybe some of the first that realized that cyber operations could have profound implications for armed conflict. And so they were very quick to start discussing it and starting to see how do cyber operations fit in with humanitarian law, with the law of armed conflict. So for these and for other reasons, we ended up spending years discussing cyber operations primarily through the lens of the laws regulating armed conflict. And that's both the jus in bello, the laws regulating the conduct and protection during conflict, but also the laws of the jus ad bellum on the resort to force. You know, what is an armed attack in the context of cyber and so on. So it was all sort of the legal lens that we talk about war was being applied constantly to the cyber field. And if you look at the first Tallinn manual, which was published in 2013 under the auspices of the NATO Cooperative Cyber Defense Center of Excellence. I mean, this was a prime example, right? So this was an excellent book, the first Tallinn manual. It had a group of outstanding experts gathered together, and they provided us with a summary of many of the rules of the jus ad bellum and the jus in bello, and analysis of how they might apply in the context of cyber operations. It had parts that were contentious. And many of us agreed with some parts and disagreed with other parts. But you know, that's to be expected from any efforts like this. But the biggest, I'd say, the single biggest problem, at least from my perspective, with the first Tallinn manual was that it just went ahead and further entrenched this idea that cyber operations are primarily a matter for international humanitarian law. And I don't think they did this on purpose, but producing a manual that dealt with just almost exclusively jus ad bellum, jus in bello, laws relating to war, armed conflict, and talking about cyber operations just strengthened this perception. And the difficulty here, of course, is that so many of the cyber operations that actually take place are probably not the kind of thing that fit in with the laws of armed conflict. There's all sorts of other bodies of law that we need to be looking at, and it's a little more complicated than just sort of trying to squeeze them into international humanitarian law. And to the credit of the people leading the Tallinn Manual project, and Professor Mike Schmidt and others, I think they were very much aware of this. And they therefore decided to swiftly move on and produce Tallinn 2. So, you know, before people had even realized what was in Tallinn 1, the talk of the next Tallinn manual was taking place, and they moved on very quickly, and they produced Tallinn 2 very quickly. And if you take a look at the second edition of the Tallinn Manual, it becomes very clear that so many cyber operations don't fall within the realm of acts of armed conflict, and the manual addresses other areas of law, dealing with questions of sovereignty, jurisdiction, state responsibility, attribution, other branches of law, air and space law. It goes much further than the first manual. And now that we've had this, the new Tallinn Manual out for quite a few months, I think it came out in February, was it? Yeah. I think in February of this year. This, I'd say, is a perfect moment to pause and to reflect on where we stand with our current understanding of how international law regulates cyber operations, where humanitarian law fits in or not, what are some of the challenges that still remain, whether the Tallinn Manual, the second edition, has answered the problems that we identified first time round or not. And for this purpose, we have an excellent panel here of experts who are going to share their views with us. They'll be happy to discuss questions after their presentations. And I will introduce all three of them all together, and then we'll move on to the presentations. So the first presentation will be by Dr. Heather Harrison-Dinnis. Heather is a senior lecturer at the Center for International and Operational Law at the Swedish Defence University. She focuses on the impact of modern warfare on IHL, in particular emerging technologies, cyber being one of them, but others including autonomous weapon systems, human enhancement, and more. She's the author of one of the better books out there on cyber operations and international law, Cyber War and the Laws of War. And she's also served as a member of advisory groups to the Swedish government on a number of different technologies, the International Law Association study group on cyber terrorism, and she is currently a co-editor and one of the experts in a new manual in a different area of new technologies, a manual on international law applicable to military uses of outer space. After Heather, we will turn to Dr. Roberta Arnolds, who is a public prosecutor in Lugano, also a guest lecturer at the University of Lucerne, where she teaches on war on terror. Her research is on terrorism and the challenges to IHL by new technologies, including cyber warfare. Roberta has worked as a legal advisor in the Swiss Defense Department. As a barrister, she was also part of the Center of Competence of International Criminal Law and the Anti-Terrorism Division of the Federal Attorney's General Office. She's been the editor-in-chief of the Military Law and Laws of War Review and has taught and trained on related issues in many places and published widely in the fields of IHL and international criminal law. We will then have Professor Robin Geiss, who is a professor of international law and security at the University of Glasgow. He's a former legal advisor at the ICRC and ICRC delegate to the UN Human Rights Council. He's the director of the Security Governance in Areas of Limited Statehood Project, editor of the Yearbook of International Humanitarian Law, and it says rapporteur of the International Law Association Study Group on Cognitive Hostilities, but that study group's finished, isn't it? Right, so a former rapporteur, or rapporteur of a former study group.
Much delayed ILA report.
Yes. I didn't, I stayed silent on the delays. Robin was part of a group of experts involved in the Tallinn Manual, so he has an inside view on much of this, and he too obviously works on issues relating to cyber operations and more generally law of armed conflict and new technologies. So with that, I'll turn over to the presentations. Each speaker will speak for around 15 minutes, and after that we'll have open discussion. Heather, over to you.
Thank you. Oh, and thank you for a lovely introduction. So as Norm said, the Tallinn Manual, the second version, is significantly expanded. For those of you who saw the original one, it's sort of this big, and now we've got this massive, and now green, volume. The previous one was blue, just for optical sake, but it expands from mainly talking about the law of armed conflict into talking about more general issues of public international law. And it's brought its authority, its analysis of its group of experts to deal with all of these issues, including some specialized areas of international law, as Noam pointed out. And the main difference is these operations that are happening below the threshold of an armed conflict. And to be perfectly honest, that is where most of the cyber operations that are happening today are happening. We're not seeing massive use of cyber operations in armed conflict. We are seeing some, and they're proving quite fascinating. But the majority of cyber operations that we're seeing going on in the world today are happening below that threshold of armed conflict. We've seen a lot of increase in states using tools of cyber operations to further both their foreign and domestic agendas, domestic policy agendas. We've seen, amongst other examples, alleged election interference in the United States, probably the most public one, but also in France and in other places. We've seen hacks against power grids in Ukraine. Query on whether or not that is below the threshold or actually taking place in the context of an existing armed conflict. In the last week, we've seen reports that the US has temporarily cut North Korea off from the internet as part of their sanctions package against that country. Allegations of increased cyber espionage. We've seen hoarding, exfiltration, and disclosure of exploits from national intelligence agencies by parties unknown, at least unknown in the public domain. I should point out at this point, I have no access to classified information from any country, so everything that I'm talking about is all gleaned from public sources. So we've seen groups like shadow brokers selling and disclosing exploits that have been gathered by the NSA, by the CIA. We've seen WikiLeaks disclose CIA packages. We've seen the use of those exploits in other attacks. So the NotPetya attacks, WannaCry both used exploits that had been disclosed by shadow brokers that had formerly belonged to the NSA. We've seen ransomware attacks that may or may not be cover for other motivations. Again, look to NotPetya, WannaCry. So we've seen this huge increase in cyber operations, and a lot of those have just happened in 2017. Just this year, we've seen this massive increase. So it's really timely that the Tallinn Manual has come out, has lent their authority and their opinion to these sort of below the threshold questions. I should make the point that the Tallinn Manual is a manual. It's not law in and of itself. For some of you, that will be self-evident. For others of you, it bears repeating. It is the view of 19 experts, but it does not constitute law. It constitutes the best guess of those people on how the law should apply to cyber operations. Obviously, it's an educated analysis, but it is not law in and of itself. But one of the most interesting outcomes of the Tallinn Manual and the release of the Tallinn Manual is perhaps how it's prompted a renewal of discussions about some of those principles of international law and how they work in the cyber realm. So, for example, there's been a renewed interest in the concept of sovereignty itself, and whether sovereignty is a primary rule in and of itself that can be breached and a state can be held responsible for, or whether it's just an underpinning principle that sort of underpins actual other primary rules that breach. For those of you who are interested in reading further, there was a fascinating discussion in the AJL, American Journal of International Law Unbound, between Gary Korn, got the right Korn, there's two, maybe three of them, but between Gary Korn and a co-author and Mike Schmidt and Lise Verhul, who were the managing editors of the Tallinn Manual, and also some other participants in the Tallinn Manual process, on what exactly the status of sovereignty is in international law and how one might breach that with cyber. So the Tallinn Manual position is that you can breach cyber in one of two ways, either an infringement of territorial sovereignty, which you can imagine might be a little bit tricky to envisage when you're talking about remote cyber operations, or if you're interfering with something that's an inherently governmental function, of which there is no sort of definition in international law. So there you can think about some of those attacks that we've seen this year, the NotPetya attacks, for example, whether or not that would constitute usurpation of an inherently governmental function. When it attacks banking systems, probably not. When it starts attacking governmental ministries, then we're starting to get into the realms of interference with sovereignty of another state, bearing in mind that the primary state that was the victim of those attacks was Ukraine. Attribution on those attacks is still very sketchy, although some people have come out more firmly than others in saying that it was probably Russia behind it. But again, attribution is a big problem. It always has been and remains to be solved. And then what about those recent reports just in the last couple of weeks that the US cut off all internet connection for North Korea? How does that affect the principle of sovereignty? Is that a breach of sovereignty? As a prima facie breach, given that it was done as part of a sanctions package, then that they've got circumstances precluding wrongfulness there. But interesting questions there about whether or not it's an actual breach of sovereignty. It's also timely to have input on what the principle of non-intervention means in terms of cyber, particularly in terms of these sort of increased incidents of alleged election interference that we've been seeing going on. Something that is in the exclusive competence, the domain reservé of the state. Their right to choose their government clearly falls within that, but where is the element of coercion? What cyber acts would operate in that principle of non-intervention? Sure, if you hack the actual election machines, absolutely, that's a breach of the principle of non-intervention. But what about all of those disclosures of embarrassing emails that happen in both France and the US? Probably not so much. That tends to form more within influence operations. So leaking of embarrassing information, purchasing ads that we've seen happening on Facebook, probably not there. Then that's raised interesting questions about espionage again. Now, the generally accepted view, and the view that's put forward in the Tallinn manual, is that espionage is neither prohibited or permitted under international law. It's prohibited under most domestic states' jurisdictions, but it's not explicitly prohibited in international law. However, the amount of espionage that's been taking place and the pure scale of espionage that's possible with cyber has led a few academics to question whether or not that is still the case. When we saw big disclosures about the conduct of particularly the NSA and their operations against other states, it's led some academics to question whether the state practice in relation to that has now changed with the outcry that came out from there. I'm not sure that I buy that argument, but I think it's fascinating that we're having these discussions about things that were pretty much considered settled in public international law. But all of them are being brought to the fore again: sovereignty, non-intervention, espionage, all being brought to the fore again when it comes to cyber. How do we deal with those questions in cyber? How do we deal with the remote access, the remoteness of these operations when it comes to these things? And so one final point that I want to make before I hand over to our other speakers. Noam commented that it's time for us to reflect on whether some of the issues that we had identified with Tallinn 1 have been sufficiently addressed. I have to say that's my big disappointment with Tallinn 2. For anyone who knows my work, I have an issue with data-only attacks. The Tallinn manual position is that data-only attacks do not constitute attacks under IHL. They have an issue with the intangibility of data. I believe that to be an error. And I was really hoping when this one came out, having had debates in conferences and other fora with Mike Schmidt and some of the other people involved in Tallinn, that they would come to their senses and realize that, of course, I'm right. But unfortunately, they have not. But I would just point out here that I think that is a flaw of Tallinn too. This idea that that data-only attacks somehow are not worthy of being called attacks. It caused them difficulty when it comes to IHL with definitions of military objectives, with proportionality equations, with the obligation to take precautions in attack, and it's come back around again to sort of bite them when it comes to sovereignty and how you deal with governmental data that is implicit in inherent governmental functions being hosted remotely, either on a server in another state or being hosted in the cloud. It also causes them problems when it comes to virtual critical infrastructure. Mm-hmm. So I think that's a problem with Tallinn. But having said that, I think the Tallinn manual is a fantastic product. Don't get me wrong, I'm not saying the whole thing is a problem. I'm just saying that I was disappointed that one thing wasn't corrected.
Thank you very much.
Heather?
Thanks, Heather.
It's my turn.
Mm-hmm.
Well, being from the south, I tend to move and use a lot of my hands, so I'd rather stand up and talk from there. Excuse me, my back fainted. There we go with technology. There we go. So we are not the marketing group for the Tallinn manual, although I think most of us really like Professor Schmidt, and actually got to know him when I was a fresh PhD student. I was initiating my career as an IHL student, and actually I'm a little bit nervous because I saw that in the audience there are some senior legal advisors on IHL, and that I estimate a lot. I learned a lot through the reading, so it's a little bit different to know they're here as opposed to maybe students and researchers, but at least it's going to feed the discussion, and I'm very happy to see them here. As said, Professor Schmidt is one of the pioneers because cyber, as indicated by Professor Lubel, is one of those topics that was being investigated by people like the US Air Force, the military in the US, but then because of 9/11, the attention got diverted a little bit to terrorism until 2007, when the little European Baltic country, which is called Estonia, got attacked via cyber attacks and attracted a lot of attention because it wasn't very clear how to qualify these attacks. And from there on, alongside with autonomous systems and new technologies, also the use of cyber warfare in brackets has brought along new issues leading to the Tallinn manual. But in fact, we are here to discuss the outcomes, but my hope today is to, first of all, see what it means, cyber warfare, how this relates to IHL, how international humanitarian law applies to it, whether the old concepts of humanitarian law fit to these new technologies, and in particular cyber warfare, or whether really need new rules, and what was the approach of the Tallinn manual. And just to explain the strategy, the methodology I followed has been to look at the definitions of classifications of armed conflict under humanitarian law, and to see how the specificities of cyber armed conflicts relate to these old notions of IHL, whether we have a delta or whether IHL is up to date. And I said, especially in 2007, there have been all these attacks in Estonia, and the question was, under the jus ad bellum, whether Estonia could resort to self-defense or not, how to consider this as a crime or as an armed attack under the jus ad bellum and the UN Charter. Then in 2010 in Iran, we had the Stuxnet virus that had a very severe impact on nuclear plants, power plants, and so we came, sorry, this is not working that properly in my hands, so I have to point it probably here, right? So the question is, how can we apply, or can we apply IHL to cyber warfare? Are there any rules that regulate this new form of conflict? And what do we understand by cyber warfare, cyber armed conflicts? Do these notions have the meanings? How did the group of experts that met and convened in Tallinn try to resolve these issues? Now, I'm originally an IHL lawyer, but I've been working on international criminal law for many years. And what struck me, especially when I moved to the Federal Attorney General's office dealing with war crimes issues, was that one of my colleagues, one of my superiors actually, who's a pure criminal lawyer, said, Roberta, why do you keep coming back to me with the Geneva Conventions and IHL? We're working in Switzerland. We're dealing with war crimes according to domestic criminal law, so why don't you look straight into the Swiss criminal code? I don't care about what you consider in the Geneva Conventions. And something that struck me is that you won't find a definition of armed conflict in the Swiss criminal code. In order to apply war crimes provisions, you need to be able to apply humanitarian law. In order to apply humanitarian law, also said the laws of armed conflict among the military, because it sounds less flower power-ish than IHL. You need an armed conflict. So to define that, you have to resort to IHL. So actually the question whether a specific conduct qualifies as a war crime, and that relates also to cyber attacks. You really need to know what an armed attack is under humanitarian law, how armed conflicts qualify, how you classify them, which rules apply to what kind of conflicts. So you won't be able to detach yourself to these basic questions prior to assessing whether cyber attacks may be covered by this subject. So where are we here? Going back to the basics, I don't know how many of you are aware of IHL, how many of you are lawyers, so I just thought to go back a little bit to the basics. So the jus in bello is here, IHL. It regulates the conduct of hostilities once the clashes have reached a certain level of intensity, of quality, and it has nothing to do with the question of who was right or wrong in initiating the conflict under the UN Charter and the US ad bellum rule. And this is what Heather was talking about, the problem of sovereignty. So regardless of whether the violation of sovereignty was so strong, so severe to allow a reaction in self-defense, regardless of that, of assessing who's right and wrong, once you have a conflict between different parties, according to the Geneva Conventions, the jus in bello applies. And we have different rules depending on whether we are in the realm of a non-international conflict, that is a NIAC, as we call it, or an international conflict, that is an IAC, which is regulated basically by the 4 Geneva Conventions and Protocol 1, whereas non-international conflicts are covered by Common Article 3. There's one provision in all the 4 conventions that restate fundamental human rights that are to be respected at all times, and additional Protocol 2. And then international criminal law is a development of IHL in a way, in the sense that breaches of humanitarian law that are so serious to deserve a punishment, and which means that they have to entail individual criminal responsibility, qualify as war crimes. We have 2 categories. We have the most grave breaches that are defined as such in the Geneva Conventions and have been adequately implemented in domestic criminal law and international criminal law provisions. And then we have other categories of violations that are also very serious, not like the grave breaches, but still that deserve punishment. And all these form war crimes that can be prosecuted under international criminal law and implementing domestic criminal provisions. So in order to be able to apply this branch and this branch to cyber attacks, we need to know whether we fall in either this or this category. So You just can't get around it. So we've seen this. IHL regulates the conduct of hostilities and the protection of specific categories of people and objects. And this is where the issue of data comes in, that I will briefly talk about, that Heather raised, and I actually agree with her. But we will see how the people in Tallinn got around this problem to at least the minority group. So we've got 4 basic principles that regulate IHL. There are others, but the core ones are the principle of distinction. You always have to be able to distinguish between military and non-military objectives, that is, those that, by being targeted, enhance the conflict, bring some advantage, and those which don't. And the principle of proportionality, that is, even if you have a military target that is close to some non-military targets, let's say civilians, if the loss of the civilians, the collateral damages, are proportionate in relation to the military advantage being sought, then that's going to be lawful. You can have an attack, and that means also a cyber attack that causes collateral damages if these are proportionate. And, but again, we need the military necessity and the proportionality equation. So these rules, which are basic, also apply in the case where you use cyber as a method of warfare, and we will see how. So the first question is, how can we see whether cyber attack qualifies as an armed conflict? What are the protected objects? What about data? What about hackers and individual participants, civilians maybe? Do they fall under the applicability of IHL or not? So we've got the definition of international conflicts in Article 2. We have cases of declared war, or basically where you have 2 or more states fighting. That's the main thing to be retained. It doesn't matter how intense the attack is, as long as you have 2 states resorting to armed force, that it's enough. By contrast, in non-international conflicts, Common Article 3 is a default rule. Unless you have an international armed conflict, everything else is a non-international one. That's the other second rule to be kept in mind. This is where the tricky part comes in, especially in relation to cyber. We'll see why. Normally you have regular states, regular armed forces fighting, but in non-international conflicts, you normally have non-state actors. Now, if these belong to a party to the conflict and fit some criteria, they are being considered combatants. Otherwise, in order to qualify as a non-international conflict, under Protocol 2, the armed group needs to have a responsible commander to control part of the territory and to be able to carry out sustained and concerted military operations. Now, this is all relevant because we will see that sometimes cyber attacks do not necessarily come from state actors. They may come from non-state actors, and this is where it's important to know whether they may fit the definition of NIAC under Protocol 2. And then we have the lower threshold that Heather talks about. I mean, unless you have reached this armed conflict threshold, everything else does not fall under IHL. Therefore, breaches of rules of humanitarian law using cyber do not qualify as war crimes and will have to be prosecuted as ordinary crimes. So, and then something important was the Tadic test, but this said that in non-international conflicts, the non-state actor involved in the conflict needs to be organized. So you need some leader, and we will see this is a problem in cyber attacks in the case where you have maybe different attacks coming from different individuals who are not coordinated, who are not led by the same leader, who do not fit within a structure. I'll cut it short, I'll speed up a little bit. So to sum it up, this is the basic structure. We have international conflicts. They can be divided in international ones, non-international ones, and then we have also the mixed ones. The mixed ones are normally where you have a non-state actor being supported by a state behind the doors. All other cases are not subject to IHL. They fall under ordinary domestic law. Now, to come to cyber, how does this fit to cyber warfare? basically, in the Tallinn manual, the conclusion was that cyber operations executed in the context of an armed conflict, and this is where the basic knowledge comes to help, they fall under the laws of armed conflict. So it's enough to have an armed conflict as a context, and then if the cyber operations are being perpetrated in connection with this armed conflict, then they will be covered by the provision. That's the first rule. The second rule is whether a cyber attack on its own brings into play IHL. Now, the question is whether this cyber attack may qualify as an armed conflict. And in Tallinn, they said that armed conflicts in general, without the classification, equate to situations involving hostilities, including those conducting using cyber means. Now you will ask, yeah, what are hostilities? So in the Tallinn Manual, Rule 82, they said an international armed conflict exists whenever there are hostilities, which may include or be limited to cyber operations between two or more states. So you see, this is where the basic IHL knowledge comes to help, because this is the traditional definition of armed conflict. They just try to fit in the cyber particularity, specificity. So if you have two or more states fighting, fair enough. You can have hostilities, but if these hostilities are conducted by cyber methods, these may include or may be limited to cyber operations. Okay, thanks a lot. What are cyber operations? And Tallinn says cyber operations are a wider concept than cyber attacks. And cyber attacks are a cyber operation, whether offensive or defensive, that is reasonably expected to cause injury or death to person or damage or destruction to objects. Now, here they say, unless you have this consequence, death to persons or damage to objects is not going to be enough in order to qualify as a cyber attack, bringing into play an armed conflict and therefore IHL. Same for NIACs. Here again, it's an analogy to Common Article 3. You need protracted armed violence. It may also be included, limited to cyber operations, but you need a minimum level of intensity, and the group launching the attacks needs a minimum degree of organization. Sporadic cyber incidents. This is where Heather comes in again. Thank you for the introduction. So sporadic cyber incidents, including those that directly cause physical damage or injury, are not enough. So it's not enough to have a single episode. And this relates also to cyber attacks perpetrated by terrorists. So again, we have a problem here that unless you have damage, destruction, and a certain quality, we're not within IHL's scope. And this is a problem in relation to attacks perpetrated by non-state actors that are on the borderline between organized crime and non-international conflict. So the following question is, what do we do with respect to the principle of distinction? So under IHL, pursuant to the Tallinn Group, under IHL, operations equate to attacks. Attacks mean acts of violence. So unless you have some damage, something broken, you won't have an attack. Now, Professor Schmidt brings up the question, what if I attack a computer? I have the box. I may destroy the box. But it's not actually the computer which is going to affect me as a party to the conflict. It depends on the data that are contained by the computer. So how can we bring that into play? As Heather brought up the issue, the majority of the Tallinn Group said that data do not qualify as protected objects under IHL because the traditional notion of object in the Geneva Convention is something visible and tangible, which would mean if you destroy the computer, fair enough, because I can see it. But if I destroy something which is on an iCloud, it doesn't fall within the traditional notion. And the other reason is that in the military, they were concerned that PSYOPs, psychological operations, launched, for instance, by attacking by cyber systems, would fall within the scope. So intelligence activities, everything that falls below the threshold of armed conflict would possibly come within its application. This is why they decided data, it's better to leave it out. But the minority group argued, no, it's silly to consider the box, the computer. You have to see what the aim of the data is. So this is where Mike Schmidt came up with his imprint, and he said, well, to solve this problem, why don't we choose the functionality approach? So it depends on what the data protects. If, for instance, my data covers the functioning of some hospital or some nuclear power plant, obviously by destroying this data, I'm going to cause indirectly a major damage on people. I'm going to cause the death of various people. So it would be silly not to protect this data. Alternatively, if the data are not relevant, I can attack them without particular consequences. And his idea, he said, if we introduce the protection of data in the rules of engagement of the nations, slowly, step by step, we will create state practice, and by that we will claim that there is an opinio juris on this, that it's important to protect data, and like this we will create customary law, which is formed by opinio juris and state practice. So Schmidt's idea is to develop customary law by introducing the concept of the protection of data in the rules of engagement for the military. Civilians is a problem. We can apply the rules on direct participation in hostilities. An individual hacker is not going to be covered. It's complicated. I don't have the time here, unfortunately, to venture into this. It has to do with the TIDH overall control test. But as you see, we have various issues. And I come to the final slide before my colleagues are going to ask to raise the white flag. Okay. So IHL is a balancing of humanitarian concerns and military necessity, and there's a shifting. So you have to recall that IHL to apply requires an armed conflict. Cyber attacks may qualify as an armed conflict. It has to do with the functionality test. It depends on what you target, what the importance of the target is, especially if we think about data. Data can be protected objects. The idea is to develop customary rules on this. And depending on the nature of the participation, which we have high thresholds, also civilians joining the hostilities may bring into play IHL, but only if their participation has a direct nexus to the conflict. And again, we have to go back to the rules on direct participation. And again, this means that for breaches, you may bring into play ICL, International Criminal Law. So it's very short, but I hope that the discussion will bring some further items for research, and thank you for your attention.
Thank you very much. And Robin.
Thanks. Good evening. No, I'm Camelia, Geneva Academy. Thanks very much for having me. It's always good to be back in Geneva. This is threatening. Now, Heather has already kind of laid the ground and described all the attacks, or many of the main attacks we've seen in 2017. So I'd like to start out with some of the things we haven't seen in cyberspace so far. First of all, I think we don't have seen all that many countermeasures. Not sure we've seen any measures that have been declared to be countermeasures, hackbacks, and so on. Maybe that's not overly surprising, given the way cyberspace is made up. But if you look to the legal discussion, where the focus is very much on this paradigm of action and reaction, countermeasures, self-defense, and all of that, what can you do in reaction to a cyber operation? It's a point worthy of note that we're not seeing all that many countermeasures in actual state practice. Barack Obama, if you recall, in the run-up of the elections that got Donald Trump elected, he never said that the manipulations of the US elections amounted to a breach of international law. So not many countermeasures out there, a point to note. Secondly, I think we're not seeing actual cyber warfare. Again, we have manuals on cyber warfare, but I don't think we're seeing cyber warfare in the true sense of the term. Now, Heather has said it, of course you find examples where there are military operations pertaining to armed conflict, relating to armed conflict, in armed conflict. The US is disrupting financial flows to Islamic State. During the Georgia-Russia conflict 2008, there were cyber operations, and you'll find more examples. But what we're not seeing, and what really is cyber warfare to me, is military operations between sophisticated technological actors that aim to destroy or disable each other's cyber capabilities. We're not seeing any of these sophisticated large-scale operations. Again, I think that is relatively surprising. The US and China have both come out publicly saying that in a future armed conflict involving cyber measures, they would strive for cyber dominance. Cyber dominance necessarily means full scale. That is a global approach to dominating cyberspace. That comes close to dominating the universe if you think what cyberspace is today. So to my mind, we're not giving enough thought to what actual cyber warfare might look like in the future. It could be the case, I'm not saying it is, I'm not sure it is, but it could be the case that it is very different and occurs on a much larger scale if it involves sophisticated actors than we think today. And from all the cyber measures we've seen so far in the context of armed conflicts, I'm not aware of any that have really brought about very significant humanitarian challenges so far. But that could change if you go global and take this to the controlling of cyberspace aim as a whole. Third point of things we're not seeing a lot of progress. The two Tallinn manuals have really fast-tracked the debates, I think, and we've reached a certain plateau, but we're now stagnating on that plateau. We're not really making any significant advancements as to what the law to cybersecurity, cyberspace, military operations should be. As you will know, the governmental group of experts was unable to present a final report recently. That was a big setback in terms of making progress. We're not seeing a lot of state practice. What we're seeing is a lot of states lamenting that we're not seeing state practice, but not adding any. So that's the status quo of the debate. The G7 earlier this year, the G7 powerful states came out saying what we need to advance in cyberspace is clearer and unambiguous statements from states what they think the law is or should be. We're not seeing much of that. Now, you've heard from Noam, I've been involved in both Tallinn manuals, the first as an expert, the second as a reviewer. So I come with an inside perspective. For that reason, I'll try to be extremely critical. But I should say from the outset that overall I'm supportive, obviously, of both of the Tallinn projects, and very much so. I'd like to do three things, and first of all, look to the role of manuals in IHL generally, then look to a few gray zones in terms of cyber warfare and Tallinn 1, and then if time allows, but I see Noam is relatively strict, not sure we'll get there, ad bellum issues, the countermeasure issues. The biggest issue to me is really in all the attacks we're seeing today, at which point do they violate international law? Are they even legally relevant? Most of what we're seeing, you could at least argue it's very unclear whether it's legally relevant at all. And that rules out a whole set of countermeasures and many other reactive options we have in international law. The role of manuals. IHL has a long-standing tradition of manuals. Initially, they were very few, but they were very innovative. They were blue sky thinking, as my university would like to call it. The 1880 Oxford Manual on Land Warfare. They presented a draft of rules they thought should be adopted, a step forward. They really pushed the envelope. We're seeing problems out there, and this is what we think the law should be. Please, states, take it into consideration, do something with it. Now, the manual landscape has changed. Today, we're seeing an inflation of manuals, and they're not very innovative. Think of San Remo Manual for Non-International Armed Conflict Naval Warfare, HPCR Manual for Air and Missile Warfare, the DPH study. This is the only manual I think that pushed the envelope, but all the others not so much. Two Tallinn manuals, another manual where both Heather and I are involved, so I plead guilty, on outer space operations. An inflation of manuals, thousands of pages of clarification. I'm not sure we're really reaching that aim. IHL is starting to reach the level of German taxation law with all this detail we're adding, and that is not a good thing. And it was never meant to be that sophisticated and detailed to go to so much detail. There is a certain risk with all the manuals that we start losing sight of the forest for the trees. Today's manuals, they are more like an aspirin package insert mixed with a restatement of the law. And they have the charm of reading a telephone book. That's simply true for most of them. They still serve a purpose. And I said I'll overstep a little bit in being critical. They still serve a purpose, but they really are like a package insert, because what they want to do is facilitate the application of the law for legal advisors and so on. They simplify things. They strive for clarity, which has a certain risk that you omit certain gray zones. They really want to make it clear and simple and ready-made and accessible. That's what these manuals are about, and the Tallinn manuals both very much are on that same page. The Tallinn manual, like many of these other manuals, they are not asking what would be the best law to be applied in cyberspace. They're not following this traditional Oxford approach from the earlier manuals. What would be the optimum legal framework we could wish for if we could draft it from scratch? They're not doing this. They're asking how can we apply existing law to cyberspace. And that is good and well. I think out of all the manuals, the Tallinn manuals are the most influential, most often cited, the ones that have really filtered into the system. If you look to speeches from Harold Cole, Brian Egan, the language is very close and sometimes similar to what the Tallinn language is like. And why is this? Why is it that the Tallinn manual has been so successful, even though it didn't really push the envelope to my mind? Good PR is one, certainly, always good PR. The other is, in 2009, when we started the first manual, there was an anxiety that cyberspace is the Wild West, that there is a lack of stability and no clear legal framework at all. And the Tallinn manuals really catered to the market, so to say. They provided reassurance. They are the volume for states, because what Tallinn 1 really, really does, if you look at it from a bird's eye perspective, it really drives home the point that there is no legal vacuum in cyberspace. And I think that is the main achievement of Tallinn 1, and this is why it has been so successful, because especially Western states wanted that statement to be made and to be consolidated. There's, to my mind, two simple overarching messages in the Tallinn manual. One, no legal vacuum. There will be stability. You can rely on a certain legal framework even in cyberspace. And the other is, states, if you read the Tallinn manual, you'll know that you're not defenseless out there. There's all these attacks out there, but the Tallinn manual shows you you're not defenseless. There is Article 51. Attribution may be a problem, but here we have some measures of how these problems can be overcome. That's all good and well. That really serves a purpose. That really served a purpose in terms of adding to stability, and I think for that reason alone, this is a successful project. But it also comes with certain risks, as I said, and the risks are oversimplification and omitting of certain gray zones. A manual like this is not about problem spotting. It's more about showing you how well international law applies. And what I would like to do in the remaining time is to look to some of the problems that we're seeing. And that, to my mind, should receive more attention than they have been receiving to date. Cyber warfare, first of all. Again, I think Tallinn 1, Tallinn 2 as well, both very successful in drawing certain baselines. In 2009, that wasn't so clear, but the Tallinn 1 manual made it very clear. No terrorizing of civilians in cyberspace, no starvation of civilians in cyberspace. Important baselines, and that was an important achievement from the Tallinn manual. Now, some light criticism is perhaps in order that in the first Tallinn manual, to my mind, there's only 30 to 40% of rules that really have cyber relevance, that have something cyber specific about them where it was necessary to have a group of experts pronounce on that matter. The other 60%, not so much. And with some amusing results, you just have standard rules where the word cyber was added somewhere, somehow, to cyberize the rule. Whether you can wave a white flag in cyberspace and how you would do that, I don't think it's a priority. If superpowers are striving for global cyber dominance, we have other issues. But it does no harm, so that's not a major point of criticism. It just adds to the telephone book charm if you keep repeating rules and cyberize them. The two bigger issues that I think are open gray zones that still need more attention and much more attention than they have received to date, and that should be more in focus, is first of all the issue of bloodless attacks, and secondly, the fact that a deeply interconnected space like cyberspace just doesn't really match with the principle of distinction. If it's deeply interconnected, distinction is at odds with that space from the start. Now, bloodless attacks, what do I mean? I mean that to my mind, the legal framework we're working with was very much premised on experiences from the Second World War, interstate warfare, drastic consequences of war. And what the Geneva Conventions, to my mind, are all about is to provide basic protection, provide us against the worst consequences of war, but not against all consequences of war. Death, injury, and destruction. That's really what the Geneva Conventions are meant to protect us against. If your stocks drop during armed conflict, that's not regulated by IHL. That's a risk of life, and this is just what's going to happen in times of war. Now, the problem is that a lot of the operations we're seeing, or are likely to see, to my mind at least, in the future cyber warfare, will not necessarily meet this threshold of death, injury, and destruction. I know they can. All technical experts have an example of how you can kill a lot of people with a cyber attack. That's possible, but I'm not sure that's particularly likely. The moment you can have that in a cheaper way, it's cynical to say, but you can achieve these results with an old-fashioned bomb if you wanted to and had to in times of an armed conflict, I'm sorry to say. And if you use a cyber attack, as Stuxnet has shown, you're revealing the exploits, you're giving away the technology. Launching a sophisticated cyber attack is like handing over the weapon to everyone else. You will think twice whether you're going to do that. So what to my mind is more likely in a cyber warfare scenario is more subtle effects, manipulative effects of societal processes, larger processes, economical processes, financial processes, these kind of disruptions that don't necessarily lead to death, injury, or destruction, although I'm sure some lawyer can come up with an example where they do, but by and large, they will not. And so what you could say, I think, is that the consequences might be less drastic in terms of quality. You're not killing people with these kind of attacks, but they're much larger in terms of quantity. You're cutting off possibly millions of people from certain internet services, and the more we become interconnected and cyber-reliant, the more important this is going to be. You're affecting society at large, not the individual as it used to be the case in traditional warfare. And to my mind, we need a broader and more open discussion about what kind of effects we actually want to be regulated by the laws of war in the 21st century. That's a very broad way of putting it, but that, I think, should be the heading and the overall framework under which we should have that discussion. Where do we draw the lines with these kind of manipulative effects? What's IHL relevant? What's just an inconvenience of war, just like your stocks dropping in traditional armed conflict settings? The other problem is really the application of the principle of distinction in this deeply interconnected space. And we should really be open to test the idea of whether that still works and whether we could find better and other means for cyberspace to protect civilians against certain consequences. Now, it's a difficult time to make that statement. We see barrel bombs being dropped on civilians in Syria. No one really wants to open a discussion of whether the principle of distinction is still valid. So this should really strictly focus on the cyber context. But in cyberspace, as everything is interconnected, it's easy to see how everything could very quickly become a target. It's all dual use, and if you recall the definition of what makes a military objective, it's the military use of whatever civilian infrastructure. Now, in the physical world, there's not so many military uses for this glass, but in the virtual world, there is potential military uses for each and every cyber component. Each of your cell phones could be part of a botnet, and if it's a military botnet, that becomes a military target in the strict sense. And it's not just me thinking along these lines. If you read in the first Tallinn manual, it says, in theory, the application of the definition for military objectives could lead to the conclusion that the entire internet becomes a military target. Explicitly stated in the Tallinn manual, the entire internet. Tell that to a technical expert. The entire internet becomes a military target. Match that with the expression we're striving for cyber dominance in a future armed conflict scenario. I simply don't see how much protection the principle of distinction will grant us in cyberspace. And I think that needs more critical reflection. And that is something I think where the Tallinn manual kind of brushed over a deeper issue, because it was just looking to the rules, but the real consequences of this is that easily pretty much everything that's cyberized could become a military target, and I find that a very worrying conclusion. The ICRC, I should note, in one of their recent challenges reports, has shown an openness, at least, that we might need development in this area of the law, which I think is the right way forward, although I would acknowledge that it's probably not easy for the ICRC as the guardian of IHL to really push that topic too far at the present moment. 2 minutes, it says. To me, that means let me just say 2 more things on ad bellum and really just an impetus to start our discussion going. Tallinn 2. The Tallinn 2 manual is really about the 99% of attacks that we see all the time. What do we do with all the attacks that don't meet the use of force, armed attack threshold? And 2 observations. First observation, I think the Tallinn 2 manual provides a toolkit. And if you choose all the tools that are in it, you're pretty well set to react to each and everything that comes at you from cyberspace. The toolkit is the no harm principle, which shifts the perspective from the state that's behind a cyber attack but whom we cannot identify, because in cyberspace identification of the perpetrator is difficult. It shifts the perspective to the state that lets the attack happen. That broadens your options in terms of states you can react to. Then there's a strong focus on countermeasures. Nothing wrong with that, but I would like to see a stronger counterbalancing focus also on peaceful dispute settlement mechanisms, which is not as prominent in the Tallinn manual, I find. And then thirdly, there is a pretty strong, and to my mind, relatively worrying focus on the principle of necessity, and using necessity as a catch-all clause, because necessity neither requires a breach of international law, nor does it require attribution. It's the perfect panacea to overcome all of the problems we're discussing when we're discussing self-defense and countermeasures. But if you recall the ILC, when they drafted the article on necessity, they were very cautious in saying this is a last resort mechanism because this circumvents many of the dogmas that we have in international law. Use it carefully. And the Tallinn 2 manual kind of doesn't share that cautious approach. It's pretty prominent. Last issue, but that's really just to get the discussion going now. Another gray zone, big gray zone that is out there, to my mind, is the initial question I raised: at which point does a cyber attack actually violate international law? That is far from clear. It is evident if you have an armed attack, yes, but we rarely do. Use of force, okay. Prohibited intervention, what do we do with the coercive element? Can we translate that into a manipulative element? Would that make sense? But we really don't have any guidance. We don't have much guidance from Nicaragua. They just said coercion, so where do we go with that? And below that threshold, what amounts to sovereignty violation, and Heather has already spoken to that, is highly unclear. If you ask 2 lawyers, you get 2.5 opinions on what amounts to a sovereignty violation out there. And again, I see a pretty strong imbalance there. If a Swiss policeman goes over to France, no consent from France, he's going after a bicycle thief, trying to catch him in France, but he didn't have France's consent. He just crosses the border and catches the thief. It is very clear, and it's a traditional kind of category, everyone will agree that that is a violation of sovereignty of France, territorial integrity being implicated. If that same policeman disrupts 5,000 email accounts in France for people suspected of computer fraud, it is far from clear whether that would amount to an equal violation of sovereignty. And there are still issues out there, and they're not only in cyberspace. There are broader issues of at which point, if states do something that affects other states, I don't think we have clear dogma or clear categories which of these are actually relevant to international law and which are not. Again, you catch one bicycle thief in France, that clearly is a violation of sovereignty. But if the Federal Reserve in the US changes the interest rate, that affects the entire housing market globally, and in Europe, prices will fall or go up. That is not internationally legally relevant. They can do that. They're absolutely free to do that. But where we draw the lines and why we have certain categories and not others is unclear, I would say, generally. And now in cyberspace, we're all kind of getting closer together. Everything is more instant, happens rapidly, affects others all the time. And there we really realize this problem is coming to the fore, that we don't really have this kind of clear guidance. And I would say more blue sky thinking is in order here. Thanks very much.
Thank you, Robin. I'm trying to remember, I think might have been almost 10 years ago, we were together on a panel in Bruges talking about cyber operations, and I'm just thinking how much the debate has changed and evolved. And thinking back at some of the things that we probably said on that panel 10 years ago would seem extremely yes, basic and simplistic. I don't know, actually. Camelia, is this all on video? Yes. And it's going all online? Okay. That's okay. I was just saying earlier to some of the panelists that the problem with video things going online is that, and I've had this, someone comes to you and says, you write something and they say, but 3 years ago in a presentation you said this and that, and we're never as careful in presentations as we are in writing. But
which
anyway,
is good, and which is
fine.
good that they're video.
So three excellent presentations. There are so many other issues that could have been raised. I mean, it's endless, the challenges that are coming from the realm of cyber operations. Just to give you an example of one more, the whole issue of financial targets, right? Where they fit in more generally, right? There's been a hard battle over the years, both in the jus ad bellum and the jus in bello in relation to this. Right, on the jus in bello, in IHL, there's this debate over war sustaining or not. That you've had views, certainly from within the US, that military objectives can include war sustaining, right, and that brings you to financial targets. I think the examples are often used, going back to the cotton fields in the Civil War in the US, and cyber operations have brought back this whole debate of whether attacking financial targets should be legitimate or not under IHL. I should say, by the way, it's not just cyber in recent conflicts. It's also come up in the context of the Islamic State and oil fields and oil revenues and so on. But that debate has suddenly sort of come back, and it's in the jus ad bellum as well. Right? In the jus ad bellum, again, it was sort of long debates and battles that we thought were settled years ago, where you were saying that financial operations shouldn't be considered an armed attack, right? That we sort of excluded economic measures from armed attack in the jus ad bellum. But I would suggest that if nowadays one state attacked another, say a state attacked the US and completely collapsed the Wall Street and the stock exchange, I'd be very, very surprised if the US didn't consider this to be an armed attack. And I think many other states would respond in the same way, even though it goes against what we've sort of traditionally and for decades been saying comes within the ambit of the armed attack. So it is very possible that there will be some areas that if certain cyber operations do happen, it might change state practice, and it might make us have to rethink, whether we like it or not, some absolutely fundamental concepts in the jus ad bellum and jus in bello, and I think we need to be ready for that. Just one comment before I open it up to questions on the issue of data, and I noticed Heather, you say data. You say data, I say data. I don't know if it's tomato.
I'm from New Zealand.
Right. As a fan of Star Trek, I just think of the character data, and so I just use, for me it's always data. But whether data is or isn't an object, I mean, this is something that actually on this panel, I think we have people that all share the same view, but that's a view that is different to the
Because it's the right view.
Well, I agree. I mean, we both written on this. We both written on this, and we were both peer reviewers from the first Tallinn manual, and we both gave comments on the first Tallinn manual saying that data should be an object, but those in the group of experts didn't manage to convince the others. I mean, to me, it seems fairly obvious, for example, that if you can talk about, if you drop a bomb on, say, the offices of this university and destroy all of the institutional records of everyone's studies, right? Then that's a destruction of property, and it can actually affect the lives of people for years, right? If all the records of everything, of everyone who's ever studied here and so on, in terms of a civilian object and having an effect on civilian, we would count that as civilian property and object under IHL. But if you do this, if the records are all electronic and you do the same thing electronically and you permanently delete all the records of this institution, well, at least under some views in the Tallinn manual, that's not an object. That's not covered under the principle of distinction. And I find that to be extremely problematic. But, and this is a question to the panel, if we agree that data is and can be an object, how do we decide what data? Is it based on how much harm is caused? Because that's not how we measure things with physical objects. We don't measure what type of physical object, and this type of physical object caused this much harm to civilians, so we should count it, but this didn't. A physical object is an object, it's civilian, that's it. But what do we do with data if it is clear, and it is, I think, to some of us, that certainly some data has to be considered an object? Do we need to come up with a definition of what types, and to think about how that affects other rules within IHL? So, for example, if any data is an object, then as soon as two countries start doing any, and that's happening all the time, even in sort of in sabotage activities, immediately you're saying it's an armed conflict because you're destroying objects, you're destroying property on both sides. So how does our interpretation of data affect our understanding of what is an armed conflict? How does it affect direct participation in hostilities? Because it makes it much more easier to consider any hacker as destroying civilian objects on the other side. So is there a risk that at the same time we are lowering the entry point with regard to other rules, and how do we mitigate for that when we say that data is an object? So that's a question to you. I'll give you a second to think about it and open up to questions from the floor, and we'll take 2 or 3 questions at a time. At the back, please. Elena?
My first question is, if you could tell us a little bit more about the differences in the GTV as to the application of the law to cyber operations as such. I mean, for those countries who say, because I've never really, I understand that the West wants to say that, all international law applies, but there's another group that says no. So what is their idea about, what are cyber operations regulated by, whether it's IHL or below IHL? Because I understand that there was a difficulty in even mentioning humanitarian law, not to mention the Geneva principles, et cetera. So I fail to see, you understand my question. And my second question is, conversely, more and more often, I think I really know, it's been mentioned that the tech industry is going to some sort of Geneva digital convention that will take on, again, below the level of armed conflict, I assume, and they would have some sort of attribution authority, et cetera. Do you think that's likely to happen? Where is this coming from? And what is the reaction of governments likely to be? I mean, what's going on there? Because it's constantly, is it hot air? So many of these things are on. And then I just have a comment, which is that, I think Robin has said it already, but, and Noam's example is very telling about, if there was a cyber attack on Wall Street based in the United States, we would consider that to be, part of an attack in the IHL sense. So I think it's very clear that while the dilemma is to adapt the law to this new technology, for the kinetic operations that do exist, how do we avoid the spillover so that in the kinetic realm, all of this is not applied?
So we'll turn to the panel, then we'll come back and see if there are more questions. And so all the three panelists feel free to answer whichever one of the questions you wish. Roberta, do you want to go first?
Okay. Oops. Sorry, just to summarize your question. So the question was in 2 words.
Whether military operations that do not amount to attacks in the field of cyber warfare has been covered and like following Article 51 and 57 of the Constitution.
Well, I'm not sure I got it right, but actually, what I meant is that unless you have the an armed attack in the sense of humanitarian law, and then therefore also an attack carried out by cyber means.
Yeah, I think, okay, so maybe I take a step back. So the problem is, what does military operations in Article 51 and 57 mean? If this means only attack in the meaning of IHL, like causing injury, death, blah, blah, then only this type of cyber operations are covered. If you also think that these military operations are something else, for instance, if you move troops, is this a military operation? It might be, and it does clearly does not amount to an attack. So can you think of a cyber operation of this kind that is still a military operation, but it's not an attack?
Well, there are several military operations in peacetime, for instance, but I'm not sure I'm getting to your point.
I
Maybe
think
Can I
Yeah.
come in
Heather,
on
you've
this?
written on this.
I
so,
have. May I recommend an excellent article on this?
Yeah.
It's called Attacks and Operations. I have in fact written on it. In answer to your question, yes, I believe that those are two different things. So each 51 and 57 are expressed in terms of a basic rule and then followed by very specific provisions. The basic rule applies to operations, which is a broader category, as you've pointed out, than attacks. The very specific rules, particularly, for example, when it comes to precautions and attack, they all refer to attack and apply to attacks, but the basic rule itself applies to operations. In terms of an example of such a thing, if you could think of so you know how, well, you may or may not know, a lot of complex cyber operations these days are put together in sort of a modular system. If you think of those kind of organic chemistry things that you had in high school that you click together to make, hydrogen, helium, they're put together in the same sort of way, modular systems. You've got one that's sort of, it's a reproductive system, if you like, and then you've got one that is the exploit, you've got one that's the payload. So if you think of something that's put together like that, that's sent out by the military, that's designed to sit and wait, or it's sent out by the military and it's designed to get into position, and then if it finds itself on the correct system, to dial home and then download the payload, which is some of the coding that we've seen come out. That sort of thing, I think you're starting to talk about an operation that does not yet amount to an attack. At what point does it turn into attack? At the point it dials home and downloads the payload? At the point it deploys that payload? That's a really interesting question. And I don't have a solid answer to that. But in answer to your general question, yes, I believe that there is a difference between operations and attacks, and yes, I believe that the general principle applies to attacks. Applies to operations, not just attacks.
Want to answer any of the other?
Sure, I can jump in on all of those, but
Yeah, let's go one by one rather than person by person rather than question
Okay.
by question.
yeah.
Which
Or do you-
means
Which means Heather continue if you
goes on,
have
yeah.
anything else to say.
It means I'll just talk for the rest of the time. So there was another question about data as an object, but I just wrote down data as an object, and now I don't remember exactly what the question was, so maybe I'll leave that one for you.
yeah.
Huh?
You have more?
Well, a couple of your points, Yelena, the GGE, what happened there? I think a lot of politics is what happened there. Yes, states had signed up to international law applying, and then suddenly got cold feet about self-defense primarily. But I think, to be honest, it seems to be a lot of other repositioning going on, not just cyber, and cyber paid the price for that, happened in terms of outer space as well. So I think we're just sort of seeing repositioning of states and retrenching of states, and they were better organized this time. Instead of just being one state that was sort of, or one or two states out on the, as outliers, they had banded together and worked as a team. In terms of the Digital Geneva Convention, this is primarily coming out of Microsoft. They're the ones spearheading that, and that is because the CEO of Microsoft is a lawyer, or rather was a law student. And in New Zealand, now I don't know him personally, he may be a lovely guy. In New Zealand, we have an expression called a bush lawyer, someone who has enough legal education to be dangerous. But not enough practice. And I suspect, as I say, I don't know the man, but I suspect that may be the case with him. I noticed that they have backed off that a lot. I think his legal advisors have said to him, no, just, so there's been a lot of backpedaling, I think, on that. And I think the reason for that is that they've been told by states, this is not going to happen. States do not want to sign it. Primarily because they don't want to cut themselves off from being able to act in that arena, which is the other reason why we're not seeing a lot of statements coming from states about what they believe opinio juris to be, or what they believe the law to be, what they believe that the law should be, because they want to preserve their right to act in the cyber realm. And they'll comment on it when they're forced to, but other than that, I think that's what's going on there.
Coming back to your question, during the Tallinn Manual 1, where I was really involved in the discussions, we had endless discussions about different thresholds. Thresholds that prior to Tallinn and cyber had never seemed to matter all that much. All of a sudden they were there. And you can go to great length and detail and nuance with the threshold debates, and you will never end. But what they were all about, whether something is a military operation, whether something is an attack, whether something is an object like data, they were all about excluding certain operations, certain objects from the regulative ambit of IHL. That's what's behind it. And this comes back to what I said earlier, bloodless attacks, new effects that were not really clear how to regulate. And the approach in the Tallinn Manual was we go through this as we find it. We link it to certain specific legal issues rather than asking the broad policy question, really. In the 21st century, what kind of effects should be regulated and prohibited or mitigated, and what kind of effects are okay? I'm not sure data is an object. I think the Microsoft people will have a good claim to come with a new Geneva Convention if we see data is an object. That's not all convincing to me. Data should be protected is what is important to me. In the 21st century, saying data entirely is unprotected, and that is the result of this one view that says data is not an object. That means under IHL, you can do whatever you want in times of war with that data. That is not a maintainable position, I find, in the 21st century. And it's not a position that anyone will be able to sell to their voters. I don't find it convincing. How we achieve that protection is a difficult issue, and I don't have the ready-made answer for this, but I would like to phrase the debate in a different way, in a broader way. Data should be protected in the 21st century. How do we do it? Do we still work with this traditional object concept? I'm not so convinced. Maybe we need something else. Maybe we need to take into consideration that data can easily be copied and replicated. Maybe we don't even need all that much protection for data, but it's a different kind of debate that we would need to have, and it really goes to what do we want to regulate and mitigate in modern warfare, cyber warfare in the 21st century. And since we omitted this debate, we started out in different directions, went to great details on all of these issues, but now it's a big blur, and I would like us to come back and start all over again. And my feeling is, Jelena, this goes to your question, the Geneva Digital Convention, I'm not entirely sure where that currently is, but I have a general feeling that whoever comes with the next good idea that gathers sufficient state support, of course, but the next good idea out there, whoever it is, will have a good claim to move the debate forward. And I don't know where that debate will be coming from. I haven't seen it yet, this new idea. But I feel among states, they're all waiting. It's not going forward. Everyone is stagnating in there. projects and so on, but kind of waiting for this next idea that will move us to the next step. Whoever has it can really have influence in this debate. On the other issue, I would side with Heather. I think it was Cuba was the only state that came out publicly in the GGE, and it's obviously known that other and bigger states, Russia and China, were behind it. I don't think this was all rational. I agree a lot of it was politics. I think it was a move against militarization of cyberspace. It was unfortunate because it brought an important project to a halt, which is really saddening and unfortunate. At the same time, it's not entirely without reason to say that we should maybe rethink this action-reaction kind of paradigm. It's the most modern technological environment that we have, and right now we're treating it with the most primitive means of international law. We're not really thinking multilateralism here. Outrageous. So, I mean, there is a claim, although I'm not joining those, and I deeply regret that this didn't move forward.
Actually, I have a question to all of you, but also to Noam, because you raised the issue of attacks against financial institutions. And my concern by this kind of questions is to come to the same situation that followed after 9/11, that we're mixing up the paradigms. Because there are a lot of issues here, like attacks, that in my opinion should be counteracted by law enforcement measures, not by armed force. For instance, if I attack Wall Street, I mean, I can't see the US fighting back by using the armed force. I mean, what should they have to occupy every country from which an alleged cyber attack was being launched from? I mean, you can't counteract this type of attacks by the use of armed force. It could be a violation of territorial sovereignty, but I can see hardly how you could bring in the discussion of self-defense. States obviously would try to protect their data, but this isn't the same type of self-defense that is understood under the UN Charter. Like every private company, each of us has got antivirus systems. That's a form of self-defense, but it's a preventive measure, and this is what states are doing. But I don't see how that would fit with the notion of counterattack in terms of IHR. So I was wondering what the positions are on this.
Yeah, honestly, I think that's very optimistic to assume that if say, another country takes down Wall Street by cyber means, and I don't just mean, stops trading for half an hour, but, Wall Street collapses.
Mm-hmm.
I would be so surprised if the US did not consider that to be equivalent to an armed attack,
yeah,
and reserve the right to respond in whatever means it considers necessary, including kinetic force if they think that's the best way to respond against whoever did it. I'd be shocked if that wasn't the response. And I think it's, maybe I just think maybe it's optimistic to hope that all things will be dealt with without force. But once a country considers something to be an armed attack, because they won't say, oh, this is, a small, what are their options? They'll say, oh, this is a violation of our sovereignty. This is, no, they would use the language and the strongest language that they've got. And that is to say that this is an armed attack. And once that language is invoked, there is nothing to say that if you are attacked by certain means, you have to respond with the same means. So again, this is guesswork. There isn't, but
if I may, I very much share that Noam's opinion here, and I also think there's a certain readiness to accept this among other states. This wouldn't just be the US. Mm-hmm. If someone, the example Noam describes, you take down Wall Street, that really is a stretch. But if that happened, that is such a disruptive event. I actually see no issue in treating that as an armed attack, and I think most states, rational states, would be ready to accept that position. It's very different from traditional kind of economic coercion, which was always excluded from the use of force. If within the steps of a few mouse clicks you can take down Wall Street, disrupt world economy on a large scale, and certainly US economy, but this is a global incident. Mm-hmm. There's no doubt to my mind.
My question is, what would be an effective countermeasure? Because if attacking Wall Street would imply a violation of the existing rules, the same kind of
If,
reply.
if someone did that, it wouldn't be a countermeasure. I mean, they'd engage in self-defense. If they decided to bomb the country that did that, then that's the whole issue, right? If you say if you're treating it as an armed attack, you can simply respond by with physical force. This is like it or not. All we're saying is this isn't this is conjecture as to what might happen. But I just think the warning, to my mind, the warning signs are there. And this is there will be developments which may cause us, and this is the point I was making, which may cause us to rethink some fundamental concepts, both in the use ad bellum and the use in bello, and we need to be prepared. And I think some of the things that Robin in particular was saying about the Tallinn manual and the role of manuals and how they develop, the strengths of the manual in terms of how existing law can work, fantastic. The weaknesses might be in what's going to happen in all of these grey zones, and some of them are going to manifest in the next few years. What are we going to do then? We are perhaps a little less prepared for these eventualities.
So for those of you who are students, good topics to write on. But on that point, if I just may add one more thing, I think the key thing there that I'd really like to emphasize, it will be the scale and effect of that attack. Because we have in fact seen attacks on Wall Street and on the New York Stock Exchange in particular. So I mean, what Noam's talking about here is not just, as you say, bringing it down for half an hour or even a day, because that data is backed up and can be reinserted into the system and the stock trading goes on. But we're talking about a massive attack on the stock exchange. So just to make that clear that it's not, not
Just
of the type that we've seen.
Yeah, one more thought, just in our actual reality every day, what we should be more worried about is, I think, the subtle attacks on Wall Street that we don't see and that sip off 100 million a day or so. And I think that is much of the strategic beauty, if you want to agree with that term, in cyberspace, is that you can do things very subtly. And we're not seeing all-out attacks on Wall Street or any other financial market all the time. And I think there's reasons why that is the case. This escalation could happen, and we agree in the assessment, but I think the far more worrying in terms of policy and what we should protect ourselves against and modern and open societies against is subtle manipulation. And I'm afraid that is not making as much headlines as the kind of attacks that make all the noise all the time, but are possibly less worrisome.
A quick question or two. Well, there's one I noticed there, and then we'll have maybe one more. We'll see what the question is.
Thank you so much for these very interesting insights. My question is following up on a question Jelena already asked regarding the UNGGE and the process of experts coming together, discussing how to meet these challenges and how to apply international law to cyberspace. As probably most people know, the UNGGE didn't come up with a consensual final report this year. So I would be interested in getting panelists' views on what are the procedures we need to address these questions on a multilateral level, what fora do we need, what processes do we need, is another UNGGE the right solution, what would have to be different, maybe with a better process, maybe with another chair, but what are really the fora and discussions we need to bring things forward on a multilateral level?
And one more, and then very quickly back to the panelists.
Thank you very much. I'm Raquel Miranda. I come from Portugal, and I already moved to defend my master's dissertation on cyber warfare in the context of international criminal law. And that is the context, even though that represents, accordingly to what you have said, only 1% of the cyber operations and cyber attacks that currently occur in our world. I truly believe that we will witness in conventional and cyber weapons. And that's why in the Tallinn manual, the first manual, I was deeply disappointed because I did not see mentions, apart from IHL, because that's obvious, but I did not see a lot of mentions, and probably because of the attribution problems, but I did not see mentions to accountability, to international criminal law. And I truly believe that it is indeed possible to interpret the concepts of crime of war or crime of aggression. That I give one example. For example, Article 8 is in number 2F, that it is exactly the same as a sanctuary state in a cyber or in a conventional state, so it could happen all the time. And I was going to ask you if you truly believe that it is indeed possible in the future to see true sanctions, apart from economical pressure, apart from political pressure, true criminal sanctions in the international context, within the international criminal law.
Thank you. 1 minute each.
Yes. For me, it's easier to answer her. Well, I think you already have war crimes, and you have the general notions of war crimes, serious violations. You can try to fit it in there if you've got the context. We see that the international criminal law has developed further. For instance, specific acts that are primarily aimed at terrorizing the civilian population of the adverse party have become now a specific war crime too, which wasn't in the past. So I don't think that it's so complicated to fit it within ICL. We already have domestic provisions addressing cyber attacks, fraud, for instance. The problem is always how to identify the perpetrator. So it's more a problem of evidence and also jurisdiction. But this is where I think the problem comes with law enforcement and the response with military force that I was addressing before. But I think there are different possibilities to tackle it.
Yeah, I don't see any issue on other than exactly as Roberta pointed out, identifying who the person is behind the computer. With international criminal law, I mean, if you're looking for widespread and systematic, the internet is very handy for perpetrating those sorts of crimes. And obviously a war crime doesn't need widespread or any form of systematicity at all. So I don't see an issue with that. In terms of the GGE, sadly it seems that the GGE process is dead for now. I think it's better that it stopped rather than backsliding, you know. But there are other processes out there. They don't have the weight of the UN behind them, but they're more sort of track 2 kind of processes. They're academic processes, and hopefully in time they will come back to the UN when the time is right. Maybe not in the first committee, maybe in the 6th committee. But we'll just have to wait and see. I mean, you know, it'll be interesting to see what comes out of the next meeting.
Thanks.
I think I agree with this. War crimes are certainly possible in cyberspace, as are crimes against humanity, and any crime can be committed through cyberspace, I guess. But I wanted to come also back to the GGE. You know, the problem is this is just not the high time of multilateralism. Not at the UN, not anywhere else. Brexit, the ICC is challenged. The American president speaks of nuclear extinction before the UN General Assembly. It's not the high time. So in this day and age, I think my answer would be as to how we continue whatever works. We cannot stop trying, and certainly dialogue with those. It has been a very Western project. I mean, the Tallinn Manual is a Western project, and in view of all the tensions we're seeing in the world, we probably don't need another Western project, and we should be open to dialogue, even if that makes it difficult, no doubt. I mean, this was easy to do with like-minded friends and states that are, by and large, easily find compromise. It'll be more difficult, but it's absolutely necessary, and whatever works will get us forward. One of the many projects, it's a pluralist approach, one of the many projects that are out there will come to success at some point, hopefully.
Thank you. Thank you, everyone, for joining us. Thank you in particular to our three panelists for informative and engaging presentations and discussion. If you can all just join me for a second in thanking them.
Thank you.
Reception downstairs. Thank you.
Just the staircase nearby for interpretal.
Oh, no worries, no worries.
No, I didn't need it. Look, I've got it on my iPad. And I thought, oh, questions.
Thank you.
Thanks so much.
Thank you. Thank you.
Are you staying for a drink? Yeah.
Yeah.
Wondering.
No, we are staying for a moment.
Yeah.
Sorry, I didn't say hello. Hi, I'm Heather. Camelia, nice to meet you. Wow, that was
Totally.
intense.
I'm not too well, and I'm a bit trying to buy a house. And it's been all.
Yeah, no.
Are you staying for a drink? We're actually in the process of negotiating today or something.
Oh, wow.
Where?
In Berlin. From now. From West up north. I'll give you the details.
Yes.
100
Please go. Yeah, go there. Don't.
Humidity in the basement and so which all need to be considered, which makes it a big project. Yeah.
Leave the people.
What constitutes commercial espionage?
I have water in the. I bought a bottle, so I don't need it. I'm good.
I was having a big discussion today with the director of the Youth Library about soil and
Yeah, I mean, the thing about OPSN was, the thing that I saw coming out of the US was like, well, you know what? If I'd had that opportunity, I would have done it. You know, the guy who's in charge of it. So I mean, the OPSN, they're like, well, it's embarrassing, but that's espionage. That's that's okay. The Sony hack, the Sony hack was interesting because we did actually see countermeasures come out of that.